Hi, this is Valerie Guillaume, and I'm making this recording today because um, I have a hearing coming up in the appellate court, the divisional court, and I am concerned as a self represented person that my rights will not be respected by the judge. The judge at this hearing is Justice Trimble, and I'm concerned enough because Um, I have found that throughout this proceeding that the court was not respecting my rights. The court is willing to overlook some things that it shouldn't, and I'm referring to the same judge. So the hearing is coming up tomorrow, which is the 29th of August, and I'm concerned enough to make this video because the respondent, the regional municipality of Peel, is really asking the court to do some things that it shouldn't be doing. And I have already seen that these people has no scruples as far as Jennifer Bruce, who is the lawyer for the regional municipality of Peel. So just to give you a background of um, what I'm talking about is that Peel region is a respondent in my legal proceeding with the landlord, Park Property Management, and its property manager involving an injunction I got against them to stop them from renting an apartment. So this matter has been ongoing because I'm in a shelter, and what Peel is trying to do, what they've done basically, is to act in a conspiracy. So they committed civil fraud and also civil conspiracy, as well as criminal conspiracy, as far as I'm concerned, to defraud me out of that economic opportunity, which is to get the apartment and to be able to move out of the shelter. What they've done is basically, I believe, acting a conspiracy with the landlord to not um, allow me to have the apartment. Okay. Um, so this has been ongoing in the court. So what happened right now is that another judge, Stuart J., acted, in my opinion and in the opinion of the law, because I was not able to um, attend the hearing. So she made that judgment against me, evicting me from the shelter. However, I filed my notice of appeal and I got a certificate of stay, and the order stayed. Now, appeal, that was done by the registrar of the divisional court, by the way. But Peel has now moved forward um, with their motion to try to have this stay lifted. The whole point of this video is the circumstances around the lifting of the stay. Um, First of all, we had a case conference back in June, and the judge, Trimble J., stated what I feel is his personal opinion on the matter, which is that he does not believe that the automatic stay applies to my situation, the order. That's his personal opinion. What I've done is to, in my responding motion, is to provide case laws from the higher court, which is a court of appeal, um, convincingly supporting my argument against the lifting of the automatic stay that Peel is requesting in their motion. So the last time we were in court was on July 29th, and um, at that time, I think you can look at my other previous videos. My device malfunctioned, so I was not able to hear Peel's submissions, and that's where it left off. So since that time, um, the judge has made in his endorsement that we can come back on the 29th, and also the transcript of Peel's submissions was provided to us by the court. So I've had time to look at it, and to now at the hearing tomorrow to respond to it. Um, but I'm concerned because, as I said, when you're self represented, you're not respected. Okay? You're not respected. And I'm concerned that this judge is going to move on his personal opinion, not the case laws that I've presented in my responding motion materials regarding the lifting of an automatic stay, which, by the way, um, these are Court of Appeal cases, precedents that were set by the Court of Appeal that this judge is bound by as far as the principle, the legal principle or legal document of stare decisis. I can never pronounce that properly. Where whenever there's a decision made by a higher court, such as the Court of Appeal or the Supreme Court, the lower courts are bound to adhere to it. So I was working today on trying to include some of the case laws from the higher court, which goes against what this judge is doing. Okay. Um, because as far as I'm concerned, he's moving on his own personal opinion, not that I provided case laws to support my argument against the lifting of the automatic stay. So he's doing a number of things. Um, what I'm concerned about is the fact that he has stated his opinion on the automatic stay, which may or may not be based on what the law says. Okay, it's not because, as I said, I believe I've provided convincing evidence that the automatic stay does apply to my situation. However, I also, in case in the alternative, also file a motion for the stay um, against Peel's motion. But it concerned me because, as a self-rep person, this judge does not feel that he need to change his opinion on the matter. So there may be a miscarriage of justice in regards to that if there were case laws presented by me, which were made by the higher court, the Court of Appeal for Ontario, that this judge now wants to ignore and just to proceed on what he believes um, that situation is. So sorry, one of the case laws that I have included here is in regard, I have here where automatic stay under Rule 63, but there's a case by Court of Ontario which is sorry, um, Ontario Eminem's Ohms versus 2088556 Ontario Inc. And this is a 2020 case before the Ontario Court of Appeal, and it was heard by um, Justice Pasioco. So at paragraph 3, pretty much it says, and this is their motion, Eminem moved to set aside a certificate of stay relating to the cost order, because that also, my order also obviously include costs, because I did not win that motion because I was not at the hearing and the judge issued costs against me. So it is a court order for costs. So this judge, in his decision, in his ruling from this other case, so the respondent had moved to set aside a certificate of stay relating to cost order under Rule 63, which is the same as mine. And then he goes on to say, I address both motions. And then he went on to state that for the reasons below, I find that the cost order was automatically stayed under Rule 63.01 and do not set aside the certificate of stay issued by the registrar, which is the same exact situation as mine as far as the stay order, which I received from the registrar after filing my notice of appeal. So in paragraph 16, he went on to say that after filing the notice of appeal, 208 Ontario requisition from a certificate of stay from the registrar of the court relating to the cost order, which was granted. Again, that is also exactly like my situation that I'm facing here. So the respondent in that case was arguing that Rule 63.01 did not apply to the automatic stay, which is also the same position of Trimble. And this judge differs in his opinion from Trimble, and he stated that in the order. Um, Let me just go back to my recording while I'm doing something else. So I am concerned of that. I'm concerned about that. And I am multitasking right now. Okay, so I am multitasking right now. So please bear with me because I'm going to try to bring up the actual order, um, which is in my factum. Okay, that's their responding order. So, okay, there's also other issues involved in regards to this legal proceeding. Number two is that Peel wants to just walk into the court and arbitrarily have the judge just lift the stay order without also passing the three-part test for lifting an automatic stay that was also set by the Higher Court, the Court of Appeal for Ontario. And because she's a lawyer, um, and I'm self-rep, she just feel like she should just have that in her favor, not having to pass that three-part test, which is pretty much the same as the test for requesting a stay. So she wants the judge to just lift the stay and for me to be evicted from the shelter, which it doesn't work that way. Okay. Um, I know the first part of the test is in regards to the financial situation involving the person who is requesting the lifting of the stay. And we all know that Peel Region, as the local government, the local municipal government, does not face any financial hardship, which is the first part of that test. So she's trying to bypass all of that. The third concern I have is in regards to the fact that Peel Region, and I had to go and do some more legal research. Peel Region has no jurisdiction conferred upon it as a municipality under these two statutes, these two provincial statutes, the Municipal Act of 2001 and the Housing Services Act. Peel has no jurisdiction to act outside of its service area. So Peel Region Service Area, or rather the municipality, the regional municipality of Peel Service Area is only Mississauga, Brampton, and Caledon. So when Peel went to the court in its motion um, and wanting now the court to relocate me outside of the region of Peel, it is actually acting unlawfully because it has no legal authority or jurisdiction conferred upon the municipality of Peel to take any actions outside of the service area. That's as far as where its jurisdiction lies. Okay, so and this applies to all municipalities under that same act, which is the Housing Services Act in Ontario. So Peel cannot work with another municipality as far as this particular situation to say come to an agreement to relocate me or anyone else in this situation outside of the region of Peel. That's going outside of his um, legal jurisdiction in this case. So in the case of Peel, there are actually four um, set of laws that govern its actions right now before the court. Number one, some of them are provincial statutes, some are federal, and some are international human rights laws as far as this housing situation, homelessness situation that I'm facing. So, number one is the Municipal Act. It governs Peel Region, and Section 14 of that act specifically state that um, if the Peel's policies and bylaws and things like that comes into conflict with any other act, then those policies and regulation, which Peel Region is stressing in the court, that its reason for wanting me evicted for the shelter is because it cannot carry out its policies and regulation the way that it should, which is a huge lie. So, but its own act that governs it as a municipality in Section 14 states that if those same policies and regulation comes up against a statute, such as the one that it oversees Peel Region as a municipality, such as the Housing Services Act or the Municipal Act, those are provincial statutes. Or let's go to the federal level now, which is the Housing Services, not the Housing Services Act, but the federal, the National Housing Strategy Act, which was enacted in 2019. So you have those three: Municipal Act, Housing Services Act, those are provincial, and then you have the federal, um, the National Housing Strategy Act, which is federal, okay, which also Peel's bylaw can come up against and try to override those ones. And then you have the number four, which is the human rights um, standards, and those are laws, by the way, because Canada signed those treaties. Okay, so you have those ones under several mechanism with these United Nations governing bodies. Okay, such as the International Covenant on Economic, Social, and Cultural Rights. Um, those that one deals specifically, or rather, I should say, deals a lot with adequate housing and homelessness and things like that. So Peel Region is going up against all of those four ones, okay, and trying to ignore it and saying to the court, we want you to override these other statutes, which has supremacy over Peel's policies and regulations and bylaws and things. These are statutes, right? So these federal laws, these especially the federal laws, I'm not including these outside human rights laws, which, by the way, human rights laws, international human rights laws, are enforced through the courts. So this also applies to them. But the federal laws, such as the National Housing Strategy Act, has paramountcy over over the provincial laws and over these uh, rules and regulation that Peel is trying to have the court enforce against me. But the main concern that I'm trying to state here is that Peel acted outside of his jurisdiction, outside of its legal authority, to now want the court to relocate me. I didn't even mention the charter, those other lies. I didn't even mention the human rights code. I didn't mention those other laws. I just mainly focus on those provincial statutes and federal statute that deals primarily with the housing and the homelessness situation. And all of them, especially the one under the Housing Services Act, uh, specifically do not give Peel Region any legal authority to act outside of its jurisdiction, meaning that Peel cannot um, take it up on itself to go and relocate anyone, because that would be now acting outside of its jurisdiction, because its service area is only for the region of Peel, or the regional municipality of Peel, which involve those three um, cities: Mississauga, Brampton, and Caledon. So, what has been happening is that it has been acting unlawfully in regards to that situation, and no one at the shelters have had enough legal knowledge to really challenge it and saying you are acting outside of your authority, you're acting outside of your jurisdiction as far as what the act states that you can or cannot do. Okay, so that's one of the situation that um, I am facing right now, with Peel wanting the court, which enforces the law, to now act outside of the law itself. Because the other thing I want to point out too is that, let's just say there's a conflict now between the provincial statutes, which Peel is under, which is the housing uh, standards. No, that's the federal one. Oh my goodness, my memory is so bad. Housing Services Act. Sorry. Let's just say that that statute is valid, and but it now comes up against, say, the National Housing Strategy Act, or my charter rights, or the Charter of Rights and Freedom, or even the Human Rights Commission, like the code, Human Rights Code, under the Federal Human Rights Commission. The law says that those federal laws has paramountcy over the provincial statute that governs Peel region. So if Peel is doing something that is violating my charter rights, which is a federal law, it's part of the Constitution, and obviously that's a federal law. And even in Section 14 of the Municipal Act, which is a provincial statute, states that if Peel's policy comes up against those other acts, meaning those federal laws, let's say, those laws, it has to concede to those laws. It cannot override those laws. It has paramountcy over Peel's ridiculous regulations. It even has paramountcy over the provincial laws that governs the municipal law, the municipal region of Peel. So I am concerned that all of these things that Peel is asking the court. The third thing that I want to mention in this video is the fact that this appeal as is proceeding through the court. Okay. At the case conference, Trimble made in his endorsement set preemptory dates for us to abide by, myself and Peel Region. So, for instance, the preemptory date for me to perfect my appeal was, I think it was in June sometime, and that has been done. I've perfected my appeal, I've filed, I've served Peel with it. The court is aware of it. It's been filed with the court. So this is proceeding through the court. Okay. One of the things I noticed is that Peel did not file their responding appeal documents to my perfected appeal that I've served on them, and also on the landlord park property management. So Peel didn't bother to even respond to the appeal that was served on them, not the initial appeal that was filed back in May, the perfected appeal I, that I filed with the court, saying I've perfected my appeal book and compendium and exhibit book, and all of these things were filed in P region, and they had until August to file, and we're now at the end of August, and they have not even filed anything in response to um, my perfected appeal. So this is interesting because a motion judge has no jurisdiction to dismiss an appeal. So my appeal is going through in this court. So now it's going to be weighed on, would this does this judge have a right to end my appeal in this court, which is divisional court, by um, giving Peel Region what it wants, which is to lift the automatic stay. Because here's what happened: the order has been stayed. I have the certificate stayed. They've been filed with the sheriff's office, all of these things. So is the landlord's. So the landlord's um, order has also been stayed. So there were two injunctions that were issued. One was to stop the landlord from renting the place. The other one was the mandatory order was to order Peel to put me back into the shelter, in their shelter system. This was done by Justice Fowler. So the full hearing of that mandatory order, I was not able to attend that hearing. I was on medical leave. So Stuart J now um, made that order against me, which has been stayed and which now is being appealed in the appellate court. The appeal has been perfected, and it's been acknowledged by the court that they have received a perfect appeal, and um, they're proceeding as they should in the court. However, appeal filed this motion to have the automatic stay lifted, and it doesn't feel like it needs to pass the three-part test for lifting an automatic stay. It doesn't feel like the judge should take any regards to the fact that this matter, this appeal now has been perfected, and it's now outside the jurisdiction of this judge to now end this appeal. Okay, because a motion judge does not have the jurisdiction based on the case laws that I've looked at to dismiss an appeal because it's going before the three panel judges. That's what divisional court, the appellate court does, or the court of appeal, right? Three part of, I think with the court of appeal, it could also be a three-part or five-part panel. Okay, I know at least three. So this appeal now is going before the panel of judges, before the divisional court. I mean, there's no stopping it. Because if they think that the motion judge Trimble can dismiss my appeal, he doesn't have the jurisdiction to do that. It's going before the panel. Okay, it's been perfected. I have filed my appeal book and compendium, everything, exhibit book, book of authorities, everything. It's been filed. Okay, so I'm running up against these roadblocks where, because I am self-represented, um, my rights are being violated by the courts. So the biggest concern I mentioned was the fact that I believe personally that instead of going by the case laws that I've presented, which the the judge is bound by because these are Court of Appeal precedents that's been set. So as a judge of the lower court, divisional court, he's bound to uphold those precedents that were set by the Court of Appeal as far as um, the stay order from the court or the stay order, whether it's by the registrar or whatever, it's a stay, um, and the lifting of the stay. He doesn't feel like it apply, and I don't really care for him to make a decision based on his personal opinion. I want him to make a decision based on the um, the other decision of the court, the previous decisions of the court, which he's bound by, whether it's decision from the very same court, divisional court, or from the higher court, whether it's the Court of Appeal or the Supreme Court, I don't care. He's bound by them. Okay, he's bound to respect the case laws of his own court and also of the higher court. Okay, so and these are recent case laws. If you recall, I said one of the case laws that I've mentioned is a court of a court of appeal decision that was made in 2020, so fairly recent. Okay, so that's not going to change anytime soon. So he's bound by that. My concern is that he's going to continue to disregard it and saying that the automatic stay does not apply instead of looking at the case laws that I've presented, such as the one from um, Justice, I don't know how to pronounce his name. His name is, let me go back to the top of this thing, um, Pasioso. I actually want to pull up the actual um, case law, uh, but I'm going back and forth between these two screens, and I really don't want to show personal things in my email because I'm going to my sent document where, you know, I did service on the respondents, and so that's private. I should have pulled them up earlier. Anyway, so that is my concern. My concern is that the judge may not consider that Peel Region is acting outside of its authority in requesting, not to mention the fact that it's a violation of my charter rights. As far as Section 6 of Article 6 of the Charter, mobility rights, that's a straight out violation right there, because it's trying to relocate me against my will, forcefully relocate me outside of the region of Peel. So, what it has also done is to stop its services to me as a resident of Peel, because I'm currently living in Peel. So, it decided that it's going to cut its services. It cut off the housing subsidy grant, or whatever you want to call it, benefit, um, which would allow me to be able to afford renting an apartment, whether it's this apartment or another apartment or whatever. So it made some move to really cause me serious harm. Now, my claim is pending against them, okay, but not just against Peel Region. As far as I'm concerned, there are people in the provincial government, such as the one that oversees the regional municipality of Peel directly, meaning the Ministry of Municipal Affairs and Housing. So there are people there, such as the Director of Housing, Tanisha Lewis, and even the minister itself. The law states that if there's corruption, and there's major corruption in this situation here, if there's corruption involving the people within his ministry that he has not really looked into, then that's going to fall on his shoulder, right? Whether it's the minister or the deputy minister, because I have contacted them and said, this is what is happening. There's a legal claim that is pending against Tanisha Lewis and against various Peel um, region employees, including the director, Aileen Baird, Christiane Commons, who's a supervisor for the shelter. So they owe me a legal duty, a fiduciary duty, to look into my concern, okay, which they're being slow, really slow at doing right now. I don't care what your title is, whether you're called minister, deputy minister, director, or supervisor or manager. If you cause me harm, I will enforce my rights in that. And this seemed to be the situation. So I'm not intimidated by their big title. If they have to be named as defendants in my claim, they will be naming my claim, or they have been naming my claim. If I have to proceed with this matter before the International Criminal Court, which it is going before the International Criminal Court, they will be named as defendants in that ICC court. The rule of law is that no one is above the law, and I don't care about your titles. They all have a legal duty to me, not to cause me harm, not to cause me harm on the international human rights standards, which Canada has legally bind itself to. They also have a legal, um, I also have a legal right under Canada's own constitution and constitutional laws, including the charter. These people have violated everything. And because I'm self rep, they think that um, I should just settle for my losses. And they don't have to face any kind of liability. They don't have to face any kind of prosecution because they are untouchables because of the position that they hold. They should not be. So if my case is going to be an example for other people to follow, then I think it's worth all of this suffering that they're putting me through. So back to this case law, and this is just one of the many case laws, by the way, that I've included in my responding motion materials before the judge, Trimble. And it's now, we're now just waiting to see how this judge wants to proceed on this matter, because if he thinks, or Peel Region thinks, that they're going to just dismiss my appeal, which he has no legal jurisdiction to do. But you know what I've noticed about this Judge Trimble? He's a stickler for details. I have to give him that credit, okay? Um, and one of the reasons why I said that is because when the hearing on the 29th of July was disrupted because my equipment failed, and so I wasn't able to hear Peel Region submission, and so now I have the transcript, and I said I needed to review that with counsel and all of that. So now I'm prepared to go now and before the court, because obviously in my situation I can't afford to pay counsel to come and speak on my behalf. So I now have to do that on my own. And so the judge stated in his endorsement that, he's going to appoint 40 minutes for us to argue whether or not I should even provide um, written submissions in regards to the motion, which I am hoping that he allows me to do. And Peel obviously is going to argue against that. But Peel Region itself, I believe, let's just say, I believe that the automatic stay does apply. In my case, I've provided convincing case laws that it does. Even the substantive part of the order is also under the stay. So I personally believe that I've provided convincing case laws from the higher court, one of which is I'm sharing here with my screen. And by the way, in this particular decision, the judge dismissed the motion from that case, from the respondent in that case, to lift the automatic stay. So I do want the judge to apply the three-part test for lifting the automatic stay, which he did not seem to have done at the hearing because he was stating his personal opinion that he doesn't think that it applies. Well, it applies, and he cannot just arbitrarily state his opinion on this matter. Okay, I've even if I've only presented one case law, it should be sufficient. But I had included more than one, several case laws in regards to that situation that the automatic stay did apply. And finally, my concern in a situation like this where I am in this homeless shelter and the local government is actually trying to force me to become homeless. And on the international human rights standards, I have a right, even under the federal housing law in Canada, I have a right to legal representation, which, let me make it clear now to the public, legal aid does not provide. So, legal aid in Ontario do not provide, in my situation, coverage for me to get legal representation. Okay, that should not be. They don't provide legal aid to people who are facing evictions, especially those in the shelters. They don't. What I was told by legal aid staff is that I could access the community legal clinics, which in my case has refused to take my case on. They themselves telling me we don't, what they're accustomed to dealing with is landlord and tenant matters, not evictions from shelters. So I have no legal protection as far as getting legal aid. I have to do everything on my own. And this is causing me a lot of hardship because there are other circumstances, um, such as my health. And when I have to do all of this legal work, it has a negative impact on my health. Okay. So that's one of my rights that's being violated right now under international human rights laws, is the fact that I cannot get legal representation to represent me in regards to facing this eviction. Okay, so that's a major issue. My other concern is the fact that Peel Region has been acting unlawfully as far as exceeding its jurisdiction conferred on it by the Housing Services Act, which governs that municipality, where it only has authority to act within its um, own service area. So it cannot say now I am working. And one other thing I want to mention in regards to Peel Region as a local government is the fact that the in the motion documents of Peel Region, Municipality of Peel, it didn't even state that it could do that. It says maybe, which denotes obviously a possibility, not a certainty. Okay, that verb maybe. So Peel Region itself cannot say with certainty to the court, yes, I can successfully relocate her to another region and know for sure that that's what's going to happen. It's never going to happen because, as I said, those other municipalities also is under the same act as Peel Region. None of them are given the authority to act outside its service area. So that is why Peel Region also has in its documentation maybe, because it cannot say with any certainty that it can actually do that relocation successfully. So this is my video, and it's against Peel Region, and it's against Peel Region violating my right. Possibly now the court could also be violating my rights as far as not seriously considering the case laws, the precedents that I presented in my motion material, because now, and that's a presumption of bias, by the way, the judge wants to move on his own personal opinion on the matter rather than to consider what what the previous court's decision has been on that same issue, and that the fact that he's bound by those previous court decision on the issue of automatic stay, um, with regards to an eviction, and how also that he can't just allow Peel to just try to convince the court to move in its favor by also disregarding the fact that Peel has to convincingly pass the three-part test for lifting an automatic stay, and not just think that the judge can arbitrarily grant that to Peel Region. Okay, so there's a huge problem, and that's why I made this video, because you need to understand that Canadian courts, unlike the courts in America and other democratic countries, do not record its hearing. No video recording, no audio recording. So now I have to really now contemplate if I want to jeopardize my freedom in order to protect my human rights by even requesting the transcript of that hearing, because court hearings are supposed to be public, um, accessible to the public. So I know that the judge has to agree when you request a transcript of the hearing. And one of the things I notice is that every time I go into the court for a hearing, the clerk is always reading out that the hearings are not to be recorded. That part I understand, because everybody knows that the hearings in Canada, in Canadian courts, they don't allow, excuse me, they don't allow video recordings or audio recordings. But they're taking it one step further. The court is saying you cannot disseminate this hearing either. And being specific about that, you can't disseminate it on social media, meaning that I can't talk about it, which it's wrong. It's violating Section 1 of my charter rights, because there's no restriction put on me under Section 1 of the charter as far as expressing my views and my opinions. Okay, I have a right to freedom of speech. I have a right to my opinion. And if I want to go on social media and talk about my court case, this court shouldn't be telling me you cannot disseminate this hearing. Okay, however way I want to disseminate it, that is infringing on my charter rights, Section 1 of my charter rights. So there's a lot of things wrong with the Canadian court system. And I've been talking about it for years and years. But really, there ought to be recording of that hearing where the public now is involved in it. Just like how we can see on the U.S. news or whatever American court hearing, and the public can participate in it. This is not what's happening in Canada. In Canada, which is why I made this video, because if this judge proceed on his personal opinion about the automatic stay, this would be a violation. It is an error of law because it's obviously an operation of bias on in his part. But to go through the long process of an appeal, so there's a lot of things wrong with the Canadian courts. and it's causing me a lot of suffering. But this kind of things that are happening to me, hopefully, by me doing this kind of recording and me putting this out to the public, there can be some change at some point. And someone else doesn't have to go through this. Someone else doesn't have to be forcefully forced out of a homeless shelter, being told that they can be forcefully relocated to another region outside because these people want to interfere with my legal situation with this landlord. That's why they made that decision: force her out of the shelter, relocate her, and cut off the subsidy. So no money to pay for the apartment or the place. No money. She can't be living in the region of Peel because that's where the place is. And by relocating outside of Peel, that effectively also end the service of Peel to me, which it doesn't have any right to do. So this is why this fight is going on and on. And I am not giving up my rights. So this is Valerie Guillaume making this video in regards to the legal situation involving the regional municipality of Peel and the abuse of my human rights.